High Court has three jurisdiction, which is original jurisdiction, which is both criminal and civil. Appellate jurisdiction, supervisory and revisionary jurisdiction. For original jurisdiction under civil jurisdiction, this is governed by Section 23 of Courts of Judicature Act 1964. So basically, they can try all proceedings where the cause of action arose, defendant places where the defendant resides, and the facts on which the proceedings are based exist or alleged to have occurred, and any land of ownership is disputed. So actually, I'm not going to go into detail because mostly as for non-law students, they only need to know that High Court can actually try any case. And then, in fact, Section 24 of the Courts of Judicature Act 1964 talks about the jurisdiction as well, which also includes divorce and matrimonial causes, and then or some admiralty involving High Court of Justice in England, because they have the same jurisdiction and authority as far as the matters regarding admiralty. Let me just highlight here. Okay, and then any cases involving bankruptcy or to companies, any cases involving appointment and control of guardians for infant, or appointment of guardian and infant for estates of idiots, mentally disordered person, and persons of unsound mind. Don't laugh when you look at the word idiot here, because that is actually exactly what has been used in the Courts of the Judicature Act. And then High Court also have jurisdiction on the grant of probates of will and testament and letters of administration. Now, if you remember, the first time I taught you on the who has rights over property when a person die and all, when such cases, actually you go to the courts. But if I'm not mistaken, I've also told you that anything below than 2 million, you can go to Pejabat Harta Pusaka. So depends. So basically, if a person die leaving wills, so this is only involve wills, you go to High Court. For those without will, you go to Pejabat Pusaka, provided is below than 2 million. I believe I have just made some introduction last time. Try to recall, okay. And as far as original jurisdiction is concerned, as far as civil, they can actually hear claims, more than 1 million, because anything less than 1 million, you go to Sessions Court. But for original jurisdiction, claims exceeding 1 million goes to High Court, except any other cases involving motor vehicle accidents, landlord and tenant disputes, and distress. This is the motor vehicle, landlord, tenant dispute, and distress. You go to the Sessions Court. Okay, now for criminal jurisdiction, they have this original jurisdiction, which is actually governed by Section 22 of the Courts of Judicature Act. Basically, they can try all offences which committed within its local jurisdiction on the high seas of board or aircraft registered in Malaysia. So if somebody made some of any offence on the Malaysian airline, and or AirAsia, which is registered in Malaysia, so High Court has this jurisdiction, or by any citizen or permanent residents on the high seas on board of a ship, on any aircraft, okay, or where the persons on the high sea were offences of piracy, okay, by the law of nation, or offences under chapter 6, is it 6, okay. And don't know what this I don't know, okay. So VIA, okay, or 6A of the Penal Code, and in the schedule of extraterritorial offences, or any other written law certified by the AG. So as far as criminal jurisdiction is concerned, you can go to High Court has this jurisdiction. Okay, now that is all about the original jurisdiction. So when we talks about jurisdiction, we can go, High Court has another part, which is appellate. They can actually appeal, or they can hear appeals from the magistrates and the Sessions Court. Okay, can hear appeal from the magistrates and the Sessions Court. Okay, for civil appeal, this is governed by Section 28 of the Courts of Judicature Act. So, civil appeal, they give this sort of conditions whereby value in dispute that goes to the High Court must be more than 10,000. So, if less than 10,000, you can only appeal on the question of law. So, I've summarized what's here into this one. Okay, so there is no limit on the amount of appeal from subordinate courts on matters relating to maintenance of wife and or children. Okay, and for appellate jurisdiction, any civil appeal is actually by way of a rehearing, and the court will have the power and jurisdiction on the hearing appeals, as the Court of Appeal has on hearing appeals from the High Court. So, when they talk about rehearing, they have the same power of the Court of Appeal, because it is on appellate jurisdiction. Now, the High Court can also hear appeals on the criminal cases from the magistrates on Sessions Court. So, this is governed by Section 29 of the Courts of Judicature Act 1964, where the appellate criminal jurisdiction of the High Court shall consist of hearing of appeal from subordinate court, okay, which is magistrate and sessions, according to the law for the time being enforced within the territorial jurisdiction. So, they can also hear any criminal appeals as far as a magistrate and sessions court is concerned. Okay, the other types of jurisdiction is supervisory and revisionary jurisdiction, whereby the High Court has the power to revise criminal proceedings in subordinate court or auxiliary court of proceedings, so on any civil matters, okay, or review decision made by administrator or admin adjudicating bodies, which is tribunal. So this part, which is, remember, first one, when we talk about judicial review, let me just show you judicial review. So this is the judicial review, power to pronounce the legality or otherwise of an act or statute. This is where if an administrator actually has done something procedurally irregularity on their part, the High Court has the judicial review power to pronounce the legality, whether it's void or valid. And then basically on supervisory jurisdiction, High Court has the power to control the activities of subordinate courts or tribunal. This is when we talk about supervisory. Okay, next one on the Sessions Court, the power of the Session Courts comes from the Section 59, Subsection 1 of the Subordinate Courts Act 1948. So bear in mind, if you were to head it in to me assignment, make sure you return something like this, Subordinate Section 59 in full of the Subordinate Court 1948. You can use in bracket SCA for the abbreviation SCA 1948. Only after that you can use this abbreviation of SCA. You must actually firstly introduce your subordinate courts first. Now, what are the composition as far as Sessions Court is concerned? There's only one judge sitting during the proceedings. Okay, and then Section 60 of the Subordinate Courts Act, okay, says that only member of judicial and legal service to the Federation can sit as a Session Courts judge. Okay, and then they have this criminal jurisdiction, whereby Sessions Court have the jurisdiction to try all offences, all criminal cases, other than offences punishable with death. As long as it is not punishable with death, a Sessions Court can try those cases. And then Sessions Court can also pass any sentence allowed by the law other than sentence of death. This is Sessions Court's criminal jurisdiction is concerned. And as far as civil is concerned, okay, they have unlimited jurisdiction to try all actions and suits involving motor vehicle accidents, motor vehicle accident, landlord, tenant, and distress. You don't need to go to High Court. So unlimited here talks about the monetary amount. And then for any other civil suit, anything less than 1 million, you must go to, they can try, but anything more than 1 million, you must go to High Court. And then they also have this jurisdiction to try all actions and suit of civil nature for specific performance and or rescission or cancellation of contract, cancellation or ratification of instrument. Okay. Next one on the magistrates courts, this is governed by section 76. Yeah. And then where as far as magistrates is concerned, they will sit a person during this proceedings. Yeah. And then they have two types of magistrates, one first class and the other one is second class. Okay, first class, they are legally qualified. Second class, they are majority civil servants and court official. Okay, and no one can be appointed a magistrate unless he is a member of judicial and legal service. And then they have the power to hear both civil and criminal. Okay, when it comes to criminal, first class can have jurisdiction to trial all criminal offences, yeah, with a maximum term of imprisonment does not exceed 10 years. Or which are punishable by fine. And then they can also sentence those offenders not exceeding 5 years imprisonment, fine up to 10,000 ringgit, okay, whipping up to 12 strokes, or any combination. And then basically they can try any civil action where the amount of dispute does not exceed 10,000. Okay. Now for second class magistrates, okay, they may try criminal cases where maximum punishment does not exceed 12 months or by punishable only. Okay. And then they may pass sentence allowed they may pass sentence which is allowed by the law not exceeding 6 months, and a fine not more than 1,000, or any combination of those sentences. And they may try actions of civil nature where plaintiffs seek to recover debts or liquidated demand on money from defendant not exceeding 10,000. Okay, and then last one on the civil jurisdiction of the magistrates court. First class have jurisdiction to try all actions, again not exceed 100,000 ringgit, I've mentioned earlier. And second class not exceeding 10,000, which is also mentioned earlier. So this is where the provisions provisions comes from. Okay. So that's all about the judicial courts. We're going to continue on the special courts in a short while.